words estate planning, you likely think about who's going to get your stuff when you die. While this is one question that is addressed during the estate planning process, there are other crucial topics that need to be addressed as well, especially if you are a single parent with minor children. Hi, I'm Antoinette Bone, estate planning, probate, and guardianship attorney in the Dallas-Fort Worth Metroplex. Just remember, this video is for educational purposes only and does not create an attorney-client relationship. Please seek professional legal advice for your situation. What are your plans for your children's future? There are plenty of options, so let's discuss a few of them. Minor children depend on their parents to survive. If you are not able to care for them, you likely want to ensure that they are cared for in the way you would want. By putting the right estate plan in place, you can make your voice heard with respect to who will be raising your minor children and how any money and property left to your children's benefit is used. Minor children, unless they've been emancipated, cannot handle their own financial affairs. They need an adult. If you fail to create a plan for how any inheritance you leave your children will be managed and by whom it will be managed, the courts will make that determination for you. If your child has a surviving parent that you would not want in control of the money you earned and left for your child, you had better make a plan. If that other parent wasn't good with money or is easily influenced by others regarding how to use money, your child's inheritance could be spent or handled poorly before your child is old enough to receive the inheritance. A less scary result, but one that is still less than optimal, is that the court create what's called a management trust and appoint a third party to manage your child's inheritance until they become an adult, which for purposes of receiving the money from the trust is 21 in Texas. Now, we all like to think that our children will be responsible human beings when they turn 21, but that's not necessarily going to be the case. While they may not be partying like a rock star, we should not forget that their brains are still maturing. They simply may not be ready to inherit a large or even small sum of money and use it wisely. Have you had the money talk with your child? When you die, they may have been too young for that discussion, and there's no guarantee that the person who ends up taking care of them will have that talk with them. If you don't want this result with all its unknowns, you have got to put a plan in place. One reason you should engage in estate planning is to name someone to care for your minor children. Children under the age of majority, 18 or 21 depending on what state, do not have the legal ability to care for themselves, again, unless they've been emancipated. If the other legal parent is still alive, that parent may be the one who will receive custody of your children. However, if there's no other legal parent, or if the children's other legal parent cannot care for them, you need to have a plan in place. If you do not have a plan in place, the judge will look to state law to determine the appropriate guardian. And this may or may not be the person you would have chosen. There are different ways to nominate a guardian at your death. One way is to make a nomination in your last will and testament. Your will allows you to nominate someone to be your children's guardian at your death. It also names the person who's going to wind up your affairs at your death, and it states who will receive your money and property. Although this can be done in a will, I simply do not recommend that you do this. Your will may not be probated immediately. And even when it is, that process is going to take time. And so the issue becomes, what will happen to your children in the interim? Who will be taking care of them? And that's a big, scary unknown. You can also nominate a guardian using a separate document that allows you to name guardians for minor children. This is what we recommend at our office. Using a separate document allows you to change your choices without having to update your entire will. While estate planning can be focused on death, it is also important that you have a way to name someone to care for your children in the event you're still alive but unable to care for them. In addition to stepping in when you are incapacitated, this document can be used if you are traveling and need someone to make decisions regarding your minor children's health and education. It's important to note that this document is only effective for a short period of time. For example, 6 months in some states, up to a year in Texas. Although there are some things the named person cannot agree to, such as a minor child's adoption or marriage. When and how your children receive their inheritance is an important consideration. If you do not have an estate plan, your children's inheritance will be managed for their benefit until they reach the age of majority, at which time it will be given to them outright. As previously mentioned, although they will be legal adults, they may not be prepared for a large influx of money and property. Also, you may have certain things that you want the money to be used for. Using a trust allows you to draft instructions for exactly how the inheritance is to be used. You can create a revocable trust, or you can include these instructions in your will, known as a testamentary trust. The important distinction between these two options is that a will has to be filed with the probate court, and the proceedings will be public and overseen by a judge. A properly drafted and funded trust and its management, on the other hand, can be conducted without probate, and no documents need be made public. You have the opportunity through your estate plan to name the person you want to control the money and property. But without an estate plan, the judge will have only the state law and the people before them to use in making the determination. So don't wait, make a plan. I'm Antoinette Bone, estate planning, probate, and guardianship attorney in the Dallas-Fort Worth Metroplex. If you found this content useful and would like to see more like it, please subscribe to my page, like this video, and don't forget to tell your family and friends. Thanks for watching, and I will see you next time.